Welcome back to the deep dive. So today we are basically walking into a minefield.
That is not an exaggeration.
And I don't mean that in, a Hollywood action movie sense. I mean we're looking at the career-ending, fine-inducing, reputation-destroying traps that are just sort of hidden inside the world of financial compliance.
It's a very high-stakes environment. And what's fascinating is that the mines aren't always where you'd expect them to
Yeah,
be.
exactly. We're looking at a stack of documents today covering the life of a dealing representative. Now, to someone new to this, that sounds like a fancy term for a salesperson.
hmm
But looking at these regulations from the MFDA, the CSA, the whole alphabet soup of Canadian regulators, it looks more like being a bomb disposal technician.
That's actually a pretty fair comparison. The level of precision required is intense.
Because usually when we think of breaking the rules in finance, we think of like the Wolf of Wall Street, fraud, theft, real malice. But the documents we have today tell a very different story. They suggest that the biggest risks to a financial career aren't always greed. They're niceness.
Niceness, efficiency, and the desire to be a good friend to your client.
Right. Just trying to help a client out, trying to save them a trip to the office, lending a friend $50. The source material makes it crystal clear. These are the things that can get you fired.
They are. And that's really the mission of this deep dive. We're not here to just recite rule numbers.
Because that would be the quickest way to lose every listener we have.
Exactly. We need to decode the philosophy behind them. The regulators are like the police of the capital markets, and they're obsessed with two things: client protection and market integrity. Every seemingly tiny rule we talk about today, whether it's about a condo in Florida or a signature on a form, it all chases back to those two pillars.
So let's start at the very beginning of the relationship. Before any money changes hands, before any stocks are picked, there's this thing called the RDI, the Relationship Disclosure Information.
The cornerstone document, yeah.
To me, looking at the description in the text, this just screams terms and conditions. It looks like that 40-page PDF everyone scrolls past just to click I agree so they can get on with their day. Is it actually more than that?
It has to be. In this industry, the RDI isn't just a liability waiver. It's the operating manual for the entire relationship. The source material emphasizes that this document has to be accurate, complete, and this is crucial provided at the beginning.
Right at the start.
You can't just onboard a client, start trading, and then, mail them the disclosures 3 months later when you remember.
Because it sets the expectations.
Exactly. Think of it as the rules of engagement. It lays out what you do, how you get paid, where the potential conflicts are. It tells the client, here's what you are buying, and here's what it costs. If you don't do that up front, you aren't really getting informed consent. You're just taking their money.
But here's the nuance that I think a lot of people might miss in the text. The RDI isn't just about what the advisor owes the client. It also lays out what the client owes the advisor.
I'm glad you caught that. It's so often overlooked.
It seemed almost, demanding. It says clients are expected to stay informed.
Yes. It frames the relationship as a two-way street. Regulators do not want passive clients. If a client gets married or loses their job or inherits money or retires, they are obligated to tell their advisor so the Know Your Client, the KYC information, can be updated.
Why is that so critical? Can't I just set it and forget it?
Because suitability is a moving target. An investment that was perfect for you when you were single and employed might be completely toxic for you if you're unemployed with triplets.
Okay.
The advisor isn't a mind reader. The source explicitly says clients need to actively participate. You can't just buy a mutual fund, vanish for a decade, and then complain that the strategy didn't evolve with your life.
So you've got the ground rules set. You've signed the RDI. The relationship is open. Now, let's talk about the quickest way to just blow it all up. The sources have this massive warning label on pre-signed forms.
Oh, this is the most common efficiency trap in the industry. It catches so many well-meaning advisors.
Walk me through this, because I'm putting myself in the shoes of a busy client. I call you up. I say, look, I'm traveling to Europe. I trust you completely. I'm just going to sign a blank trade form and leave it with you. When the market dips, just fill in the numbers and buy. That sounds like good service.
It sounds like good service, and it is a strict violation of MFDA rules. Dealing representatives cannot, under any circumstances, possess blank forms signed by a client, period. No exceptions.
Even if I, the client, begged you to do it.
It does not matter. The regulator's perspective here is purely legalistic. If a form is signed blank, the chain of evidence is broken.
The chain of evidence? That sounds like something out of a crime scene investigation.
In a way, it is. If the market goes south and you lose money and you decide to sue me, I have no proof that you actually agreed to the specific price or the quantity that I wrote in later. You could just claim, oh, I signed that for a different trade, or I never authorized that amount.
So it completely destroys the integrity of the transaction.
Completely. And the penalties are severe. The text notes that the mere presence of pre-signed forms in a file gets reported straight to the enforcement department. It's not a slap on the wrist, don't do it again kind of situation.
Wow.
It's treated as a fundamental breach of trust. It implies you are cutting corners on the legal validation of every single trade.
So listener, if your advisor asks you to sign a blank form just in case, you are actually putting their license at risk. Okay, so no shortcuts on signatures. Let's move to something a bit less innocent, churning or excessive trading.
Right. Now we're moving from mistakes of efficiency to mistakes of greed.
The source gives us a case study here that is, well, it's pretty bold, the Hari Prasad scenario.
This is the classic example of placing the advisor's wallet above the client's wealth.
So for the listener, let's break down what Hari did. He advised his client to sell a deferred sales charge fund, a DSC fund, and then use the proceeds to buy another DSC fund.
And to understand the malice here, you have to understand how a DSC fund works. When you sell a DSC fund early, usually within 5 to 7 years, you pay a penalty, a redemption fee.
So the client loses money just to get out.
Right. They take a hit on the exit, and then when you buy a new DSC fund, the advisor gets a large upfront commission.
Ah, I see it now. So Hari effectively told his client to pay a penalty to exit one lock-in just so they could lock themselves into a new one.
Solely so Hari could trigger a fresh commission check for himself.
It's like treating the client's account like a slot machine.
Precisely. And the source material is explicit. Transactions must have a valid business purpose for the client. Generating fees for the advisor is not a valid purpose.
Now, the text does mention that DSC funds were actually banned in Canada as of June 2022, so Hari couldn't pull this exact move today.
That's true. The regulators finally killed that DSC structure because of exactly this kind of behavior. But the principle is timeless. If you're recommending a trade that incurs costs, taxes, fees, penalties, without a clear benefit that outweighs those costs, you are in Hari Prasad territory.
And what would happen to Hari?
The regulators will unwind the trade, meaning they reverse it as if it never happened, and Hari will be on the hook for the costs. And that's before the fines and the suspension.
This leads us right into the philosophical core of these documents, conflicts of interest.
The heart of the matter, yes.
We hear that phrase constantly, conflict of interest. It feels like corporate buzzword soup, but the sources provide a framework for handling them that's actually quite structured. Avoidance, control, and disclosure.
Correct. And the hierarchy there is important. You don't just get to pick one at random.
Right. You can't just disclose everything and call it a day.
No, and that's a huge misconception. Some conflicts are so toxic they must be avoided entirely. There's no way to make them safe. Others can be controlled, say, by having a compliance officer review the trades. And then others, they must be disclosed.
Let's look at the Jonas example from the text, because this one feels very realistic for people with side hustles. Jonas is a dealing representative, but he also owns a tax firm, Pro Tax Services.
A classic dual occupation scenario. Jonas is wearing two hats.
So Jonas has a client, Adrian. Adrian needs tax help. Jonas naturally thinks, hey, I'll send her to my other company.
Which makes sense on the surface. He knows she needs the service. He knows his firm is good. It feels like he's helping.
Yeah.
But here's the conflict. Jonas makes money if Adrian uses ProTax. His advice to use ProTax isn't neutral. It's biased by his ownership.
So what does he have to do? Can he not refer her?
He can, but he has to follow the protocol. First, his dealer has to have approved the outside business in the first place. But for the referral specifically, he must disclose the conflict to Adrian in writing. And here's the key part. He has to do it before the referral happens.
So he can't just say, oh, by the way, thanks for using ProTax, I own that place, when he's handing her the bill.
No.
Yeah?
It's way too late. The client needs to know about the bias before they make the decision. That's the definition of informed consent. Adrian needs to be able to say, okay, Jonas recommends this, but he also profits from it, so maybe I should double-check the pricing myself.
Now, what about when the conflict is baked right into the products themselves? The text talks about compensation conflicts. This one seems really sticky. What if product A pays me a 1% commission and product B pays me 2%?
The guidance calls this an inherent conflict. Human nature says you will subconsciously or maybe consciously lean toward the 2%. You have bills to pay.
So do you just have to recommend the cheaper one?
Not necessarily. Product B might actually be better for the client. Maybe it has better management or lower volatility.
Yeah.
But the rules state that you cannot recommend it solely because it pays more.
Okay.
And this is the hard part. You have to explain that difference to the client in plain language. You have to look them in the eye and say, just so you know, I get paid more if you buy this one.
I bet a lot of advisors struggle with that conversation. It feels tacky.
It's uncomfortable,
Mm.
but transparency usually is.
Oh,
If
yeah.
you aren't willing to have that conversation, you probably shouldn't be recommending the product. That's the litmus test.
That's a good rule of thumb. Okay, let's move to the area where the lines get the absolute blurriest. Personal financial dealings.
Yeah.
We mentioned borrowing money in the intro.
The golden rule, no borrowing, no lending.
Even if we're best friends. Even if
Yeah.
I'm good for it.
Doesn't matter. Registrants cannot borrow money from clients, and they cannot lend money to clients. There are very, very tiny exceptions, like if the client is an immediate family member, but as a general rule regarding personal loans, it is a hard no. It just changes the power dynamic of the relationship completely.
Okay, money is one thing, but what about favors? The source has this story about Larry's condo.
Ah, yes. Larry, the man who was just trying to be nice.
So Larry has a place in Florida. He has a wealthy client who wants to go south for the winter. Larry says, hey, the place is empty. Take the keys. Stay for a month on me.
Larry probably thinks he's cementing a client relationship. He thinks he's being a great guy.
But compliance thinks he's breaking the law.
Compliance sees a non-monetary benefit. And think about it, a month in a Florida condo during peak season, that's worth thousands of dollars.
So it's a gift.
It's a gift of material value. And because this benefit flows directly from Larry to the client, outside the books and records of the dealer, it's a violation. It's effectively an off-book settlement. Or, if you look at it more cynically, it could be seen as a kickback or even a bribe to keep the account.
So if Larry charged market rent, would it be okay?
Possibly. But then you get into outside business activities. Is Larry running a rental business? Has he disclosed that to his dealer? The safest path is just to keep the friendship and the finances completely separate. Do not mix assets.
Speaking of mixing assets and relationships, power of attorney. This was the biggest surprise for me in the entire stack.
It catches a lot of people off guard.
The logic seems so obvious. If I trust you to manage my money, surely I trust you to have power of attorney if I get sick, but the rules say no.
Generally, no. A dealing representative cannot take power of attorney or act as a trustee for a client. It grants way too much unsupervised control. It removes all the checks and balances.
But there is an exception for family.
There is. The immediate family exception.
Okay, so let's look at the case study of Derek and Justin. This one is really tricky. Derek is the client. He's going overseas. He wants to give his power of attorney to Justin. Justin is his brother. And Justin is also his financial advisor.
Seems like a perfect scenario, right? He's just helping out his brother.
That's what I would think. But the text says Justin cannot accept it.
Correct. Justin has to refuse.
Why? They're brothers.
Because definitions matter. Under the Income Tax Act definition that the MFTA uses for this specific rule, immediate family is defined very, very narrowly. It means spouse, parent, or child.
A sibling is not immediate family.
Not in this context, no.
That is wild. So Justin has to literally look at his brother and say, sorry, I can't help you, or I'll lose my license.
Exactly. It just
Okay.
highlights how dangerous assumptions can be. You assume family is family, but the regulations draw a very specific line that excludes siblings, possibly to prevent potential collusion or abuse between them. Justin might have the best intentions, but compliance isn't built on intentions. It's built on rules.
That is a tough conversation to have at Thanksgiving.
Better than the conversation you'd have with the enforcement department.
Fair point. Let's pivot to outside activities. We talked about Jonas and his tax firm. But what if I'm not getting paid? What if I'm just on the board of a charity? Or I'm a pastor at a church?
It still counts. The rule is outside activities, not just outside employment.
Why does the regulator care if I volunteer at a soup kitchen or run a church choir?
They care about influence. If you're a religious leader or a doctor or a community leader, you hold a position of power over people. They trust you implicitly. The regulator worries you might use that influence to pressure people into investing with you. It's all about undue influence.
So you can't be a pastor and an advisor.
You can, but it must be disclosed and approved. And usually the firm will put strict conditions on it, like you cannot solicit investments from your congregation.
It's also about how you present yourself. There's a great example in the text about a guy named Christopher Smith.
Christopher Smith, the CPA.
Right. So Christopher is a dealing representative, but he worked hard for his accounting designation. He's a CPA. So on his business card, right under the logo of the investment firm. He puts Christopher Smith, CPA.
And that is a violation of the holding out rule.
This feels a little pedantic. He is a CPA. Why can't he say it?
He can say it, but not in a way that confuses the client. By placing CPA right under the investment firm's name, he's implying that the firm itself offers CPA services, or that he is acting as a CPA in his capacity at that firm.
Which he isn't. He's just selling mutual funds there.
Exactly. It blurs the liability. If he gives bad tax advice, the client might think the investment firm is on the hook. He has to clearly separate the titles. He needs to make it clear that the CPA services are not part of the dealer's business. Clarity is king.
Okay, let's talk about referrals again, but specifically the shadow advisor problem. This is the John and Thomas story from the source.
This is a very common scenario, especially when advisors want to offer holistic planning.
So John sells mutual funds. He has a client who wants to buy individual stocks like Apple or Tesla. John can't sell those. But his buddy Thomas is a stockbroker. So John refers the client to Thomas.
So far, so good, assuming they have a written referral agreement and the firms know all about it.
But John wants to be helpful, so he sits in on the meetings with Thomas. He helps the client fill out the forms for the stock account. He acts as the go-between.
And that is where John crosses the line.
Why? He's just holding the client's hand.
He's acting as a shadow advisor. The source is explicit. John cannot advise on the stocks, and he cannot conduct the KYC, the Know Your Client, for the stock account. He is not registered for that. By helping fill out the forms and sitting in on the strategy, he's practicing outside his license.
It's like a dentist trying to scrub in on a heart surgery just because he referred the patient.
That is a perfect analogy. You have to stay in your lane. If you aren't registered to sell it, you shouldn't be touching the paperwork for it. It just muddies the water on who is actually responsible for the advice.
Before we wrap up, I just want to touch on mobility. We live in a world where people are constantly moving. The source has a scenario with Tony and Erica.
The client mobility exemption.
Yes.
This is crucial for anyone with clients who retire and move south or west.
Right. So Tony is an advisor in Ontario. Erica is his client. Erica moves to New Brunswick. Usually, Tony would have to get registered in New Brunswick to keep talking to her, right?
Technically, yes.
Yeah.
In Canada, securities regulation is provincial. You must be registered in the province where the client resides. But the regulators realized that if you had to register in a new province every time one client moved, the paperwork would be impossible. So they created the exemption.
So Tony can keep Erica.
Yes. As long as he has fewer than 5 clients in that province, he can keep servicing her existing account without full registration. It allows the relationship to continue.
But there's a twist in the story. Erica gets married. She calls Tony and says, "My husband, Robert, also lives here in New Brunswick. He wants to invest with you, too."
And that is where the door slams shut.
Tony can't take Robert.
No. The exemption is for existing clients who move. It is not a license to go and acquire new clients in a province where you aren't registered. Robert is a stranger to the firm.
So the marriage doesn't grandfather him in.
Nope. If Tony wants Robert's business, Tony needs to pass the exams and get fully registered in New Brunswick.
It's strict, but I guess that prevents advisors from just poaching clients all over the country without any oversight.
Exactly. It keeps the jurisdiction clear. It ensures that if Robert has a complaint, he is dealing with a registrant who is actually accountable to the New Brunswick regulator.
We have covered a huge amount of ground here, from accurate RDIs to the ban on pre-signed forms to the fact that your brother isn't your immediate family.
It is a lot to digest.
If we pull back to the big picture, what's the through line here? Is this just bureaucracy? Is this just people in offices inventing rules to make life hard?
It can feel like that sometimes, but no. These rules, from conflict disclosure to mobility exemptions, they're all designed to answer one single question. Can the client trust that you are acting in their best interest?
It seems like the common thread is that trust isn't just a feeling, it's a process.
That's it. We want to be nice, we want to be helpful, we want to be efficient. But in finance, efficient often creates risk. These rules enforce boundaries that human nature really wants to cross. They ensure that the trust is earned, documented, and verified.
It's not just about picking good stocks. It's about how you conduct yourself when the market is closed.
Precisely. It's about the integrity of the entire ecosystem.
Now, before we let you go, I want to leave the listener with one specific line from the source material that really stuck with me. Disclosure does not cure unsuitability.
That is the ultimate takeaway.
It means you can't just tell a client, this is a terrible investment for you, and by the way, I have a huge conflict of interest, and then have them sign a waiver and do it anyway.
Correct. You cannot disclose your way out of a breach of duty. If it's bad for the client, you simply cannot do it, no matter how much paperwork you file.
So as you go about your week, think about that distinction. In your own professional life, whether you're in finance or not, where are you relying on disclosing a problem rather than actually fixing it? Are you just putting up a wet floor sign, or are you actually mopping up the spill?
That is the question of the day.
Thanks for diving in with us. Stay compliant, stay curious, and we'll see you on the next one.